The Court of Criminal Appeals of Tennessee is now in session.
Thank you. This is the last case scheduled for argument today in our November term of the Court of Criminal Appeals in East Tennessee and Knoxville. On the panel who will appear on my right is Judge D. Kelly Thomas from Blount County, and to my left, Judge Jill Bartee Ayers from Montgomery County. My name is Kerwood Witt, and I come from Monroe County. Arguments are 20 minutes per side. If you, as the appellant, wish to reserve time for rebuttal, please announce your reservation at the beginning of your argument. Call our case, please.
Micah Ross Johnson versus State of Tennessee.
Very well. All right, Mr. Ammons, go right ahead.
May it please the court, good afternoon. I'm Franklin Ammons here on behalf of Micah Johnson. May I reserve 5 minutes for rebuttal, please?
How much?
5 minutes, Your Honor.
All right.
Under Strickland, a petitioner must prove two things. First, the petitioner must prove that a deficiency occurred, and second, the petitioner must prove that prejudice resulted from such deficiency. Here, Mr. Johnson can prove that he received the ineffective assistance of counsel. Under Strickland, the Sixth Amendment to the United States Constitution and Article 1, Section 9 of the Tennessee Constitution. This case stems from the death of Carrie Daugherty in March 19th, 2008. At issue in Micah Johnson's trial was the sole issue of his mental state at the time of offense, and specifically whether or not he could appreciate the wrongfulness of his actions under TCA 39-11-501. Simply put, whether or not he was insane as legally defined under Tennessee law at the time of the offense. In the course of representation, he had a few attorneys who worked throughout his case. However, lead counsel was a constant from the beginning of this case through the appellate process. And as part of that representation, lead counsel began almost immediately to explore preparing an insanity defense for Mr. Johnson. And as part of that, he consulted with and ultimately retained the services of Dr. Keith Caruso to perform an evaluation of Mr. Johnson. That was done, and in May of 2009, a report was prepared. This report was based on Mr. Caruso's interviews and interactions with Micah Johnson, in addition to reviewing aspects of the case. Upon receipt of that report, lead counsel reviewed it. And it's significant to note in an exhibit in the record are lead counsel's contemporaneous notes as he reviewed that May 2009 report. And what is significant in that report is a non-psychotic narrative that Mr. Johnson had provided to Dr. Caruso. Testimony at the post-conviction hearing revealed that lead counsel, upon reviewing that, contacted Mr. Caruso and inquired as to where that had come from, because it was contrary to what he had been told throughout his representation of Mr. Johnson. Mr. Caruso, or Dr. Caruso, I should say, relayed that is what Mr. Johnson had told him. Ultimately, lead counsel directed Dr. Caruso to re-interview Mr. Johnson after speaking with him, and a report was prepared in June of 2009. What is significant in the June 2009 report is the absence of the non-psychotic narrative. There is no reference to the non-psychotic narrative whatsoever. Additionally, there's no reference to the existence of a May 2009 report. As this case continued to work its way through the system, there were several addendums filed, and each of those addendums cross-reference each other. Essentially, you could read one report and it would indicate the prior reports as it went through, and each one you could work its way back. However, what is constant in all the addendums and the June 2009 report is the absence of any reference to a non-psychotic narrative. Additionally, there is no reference to the May 11, 2009 report. And The significance of this arises actually in the middle of trial. Fast forward to November 2011, and this matter is in the middle of trial. The prosecutor in this case requests Dr. Caruso's rough notes. And it's actually on the weekend in the middle of trials. This case spanned 2 weeks. Those notes are obtained from Dr. Caruso and turned over to the state. It's actually over that weekend that another attorney working on this case and reviewing those notes brought it to lead counsel's attention and indicated that there was a problem in that Dr. Caruso's rough notes referenced a non-psychotic narrative which was not present in any report. Then there is some debate in the record as to what happened next, the conversations with Dr. Caruso, but ultimately those notes are turned over. Lead counsel then recalls the prior report, the May 11, 2009 report, and that is actually turned over to the state as well. The issue was of such significance to lead counsel and co-counsel. At this time, a different attorney was serving as co-counsel that wasn't originally serving as co-counsel at the beginning of the proceedings. Was so significant that they go to the judge at the time and ask for a continuance. They're given a one-day continuance to figure out how to proceed. But at this point, they're in the middle of the trial. The jury's been impaneled. They're in the middle of proof, although they have not proffered Dr. Keith Caruso at this time. They're certainly right in the midst of trial. And what is significant is that they do turn over these rough notes and report. And obviously, when they proffer Dr. Caruso, this is where the state seizes on attacking his credibility and the attorney's credibility. It's actually when this court reviews the cross-examination that the state engaged in with Dr. Caruso, to describe it anything less than visceral or eviscerating would be an understatement. The prosecutor goes through each report and highlights how none of the reports highlight or mention any existence of the May 11, 2009 report. None of the reports make any notation or make any mention of any existence of a non-psychotic narrative. Additionally, the prosecutor asked Dr. Caruso about that report, and he thought that it was a report, and he thought it had been turned over. But again, it wasn't. And that actually came out in front of the jury that this report, it certainly had the appearance that it had been suppressed by Mr. Johnson's attorneys, that they did not turn it over until the middle of trial, and they only had to turn it over when the state of Tennessee asked for his rough notes in the middle of trial. And this is truly significant because although there was evidence in the record of Micah Johnson's mental health, and particularly his issues there, and that issue is not in dispute. This is not a case of malingering. Both parties agreed that Micah Johnson suffered from mental illness. The sole issue at this trial was whether or not he was insane under Tennessee law, and the sole witness that could make that determination and testify on behalf of Micah Johnson was Dr. Caruso. Even though there was other evidence of his mental illness, the sole issue of this case was insanity, and the sole witness that this case hinged on, from Micah Johnson's perspective, is Dr. Caruso. But the jury was left with essentially two experts. You had Dr. Caruso on Mr. Johnson's side, who it appears was either alone or in conjunction with Micah Johnson's attorneys suppressing a non-psychotic narrative. In contrast, you have Dr. Farouk, who didn't have the similar issues. Additionally, and I'll touch on it a little bit more in a little more detail in a few moments, was Dr. Caruso's academic misdeed. This significantly compounded the issue with the suppressed report in the absence of the non-psychotic narrative. Specifically, about 22 years prior to his testimony, Dr. Caruso had manipulated data, I believe, when he was pursuing his PhD. Of course, the state concluded their cross-examination with highlighting that. I think that's significant because it gave the jury the logical inference that he had once previously manipulated data to reach a specific outcome. And then again here in Mr. Johnson's case, it appeared that he had done the exact same thing, that he had intentionally omitted data or in conjunction with his attorneys, suppressed data to present an alternative narrative, which would have been the insanity narrative. And it's significant. I think both lead counsel and co-counsel testified with extraordinary candor during the post-conviction hearing. Lead counsel described the issue as devastating. Co-counsel, interestingly, testified at the post-conviction hearing. They actually didn't read all the prior reports. He actually just read the final report because he thought it was a standalone document and hadn't read the prior reports. But he described the situation as, quote, awful. And that's really significant, I think, when you have two attorneys, which I think this court is very familiar with both of these individuals who have a lot of trial experience, trying first-degree murder cases, and also have a lot of experience on trying cases where insanity is the issue. So I think it's significant the candor they testify to and the impact that this issue had in front of the jury. Because again, this case hinged on Dr. Caruso's testimony. And significantly, Dr. Catherine Smith testified at the post-conviction hearing about how this issue should have been addressed properly. What she testifies to is that it's not uncommon for individuals to present a non-psychotic narrative. There's an inclination to appear, I think she said, not to be crazy. And that's not something that's uncommon. However, it is something that has to be explained and addressed. It can't be suppressed. And what she concluded based on reading the record and reviewing the reports, that it certainly, whether or not it was the intent, it certainly appeared that Dr. Caruso was being misleading. Again, whether or not it was by himself or in conjunction with the attorneys, the jury was left with the conclusion that he was misleading on the issue of insanity. And that brings us to the next issue I want to address with the court is lead counsel's retention of Dr. Caruso. I think it's incumbent on an attorney when they retain the services of an expert, particularly an expert witness, to vet that expert. And here, although it does appear that lead counsel testified that he consulted with the post-conviction defender in Nashville about hiring Dr. Caruso, it doesn't appear that he did any independent vetting of Dr. Caruso. And I think it's significant to highlight the McLaughlin case, the Missouri case, where in that trial, in the middle of trial, attorneys who had previously retained and intended on calling Dr. Caruso had made the decision not to call him once they realized the academic misdeed. And I think the academic misdeed truly compounds the issues with the suppression of the report. And I think it's significant. And I think these two issues certainly rise to the level of ineffective assistance of counsel. And for the remaining issues, I would like to rely on my brief and reserve the last 5 minutes of my argument for rebuttal, please.
Thank you. General.
May it please the court, Catherine Redding on behalf of the state. The petitioner has not shown that counsel was ineffective for failing to present credible expert testimony and reports. Although counsel could have handled Dr. Caruso's reports differently, that is not determinative of this issue because the petitioner's sanity defense was not doomed by counsel's actions, but by the existence of this motive version of events that the petitioner provided to Dr. Caruso. This was his first attempt to explain his actions to Dr. Caruso. In the version of events that he provided, he admitted that he had sexual fantasies about the victim, that he propositioned her and killed her when she rejected him, and that he took her cell phone to ensure that if she survived his attack, she would not be able to call for help. Trial counsel was stuck with this version of events no matter what they did. The jury would have heard this version of events, whether Dr. Caruso put it in the first report or referenced in his later reports, or whether counsel replaced Dr. Caruso with a different expert. And
Well,
counsel,
given the fact that defense counsel was had this initial motive type explanation for the crime hanging around their necks, shouldn't they have done something to rehabilitate that with Dr. Caruso? I mean, counsel made a statement earlier that it's not uncommon for even psychotic defendants to try to provide a rational account of their actions to avoid the moniker of being crazy. And if that's true, then could not Dr. Caruso have explained that first account as being the defendant's attempt to appear sane, and therefore, in reality, that was a further confirmation of his insanity? Couldn't they have done that?
what happened was once counsel realized that this earlier version of events, the motive version of events, hadn't been included in any of the later reports, it did call Dr. Caruso to testify at trial, had Dr. Caruso talk about this first version of events, present it to the jury, and give an explanation of why he did not think that this was a truthful account of what had happened. So counsel, given the existence of this motive version of events, did their best to present the insanity defense even with this version. And I believe that Dr. Caruso's May 2009 report even said that this motive version of events was still consistent with an insanity defense. But then we have testimony that Dr. Caruso gave at trial, setting forth the version of events. He said, the petitioner, I talked to the petitioner numerous times, he never repeated this, and said, I didn't believe that this was actually what happened. I believe that the petitioner was insane at the time of the offenses, and gave a number of reasons for why he did not think that this motive version of events made sense, and why the later accounts that the petitioner gave were more realistic, and those were accounts that were more consistent with an insanity defense. But the situation that counsel found themselves in was once the petitioner made this statement to Dr. Caruso, and Dr. Caruso it was out there. And Dr. Caruso could have included it in his later reports, but the jury is going to hear about it. They could have hired a new expert, but the jury would still hear about it. And so the only way to address it is to have Dr. Caruso put it in the later reports and have him testify about it at trial. And so given the situation and the circumstances of how this, not a draft, actually a real report came to light, trial counsel did they took steps to mitigate the issue. But the key is that the only defense available to the petitioner was an insanity defense. That was counsel's testimony. They had nothing else to go on. But it's unlikely that the jury would have acquitted the petitioner on this basis once it heard the motive version of events, that it was going to hear no matter what counsel did. And this is especially true in the context of evidence that shows the petitioner concealed his presence at the home by walking away from the house, that he waited for the victim to come home, and when she arrived, he attacked her using 3 different weapons and 3 different methods of attack to kill her. And that after this, he went home, he showered, he gathered his bloody clothes, and he fled the state. The petitioner was not found guilty because Dr. Caruso lost credibility. He was found guilty because he gave this motive version of events that matched physical evidence. And the jury believed that is what happened. And because the petitioner can't show a probability of a different verdict sufficient to undermine confidence in the trial outcome, he's not entitled to relief. As to the second claim, the petitioner has not shown that counsel was deficient in selecting Dr. Caruso as an expert witness. The record reflects that counsel made a reasonable investigation into Dr. Caruso's background and reputation. Dr. Caruso had an impressive resume with security clearances. He was on the AOC's list of approved psychiatrists, and he was recommended by the Post-Conviction Defender's Office. Counsel knew that a number of defense attorneys had used Dr. Caruso as an expert and had talked to the Federal Public Defender's Office and the Post-Conviction Defender's Office about Dr. Caruso. And additionally, counsel had used Dr. Caruso as an expert in 6 other cases, including one where the state agreed to settle on a plea of not guilty by reason of insanity. Counsel's failure to conduct further investigation into Dr. Caruso's background, which may have discovered the academic impropriety, was reasonable under the circumstances. Because he cannot show that counsel was deficient, petitioner is not entitled to relief. And as I've previously stated, it's the motive version of events that really undermines the petitioner's insanity defense rather than any issues with Dr. Caruso's credibility. And for those reasons, the petitioner is not entitled to relief on this claim. If there are no further questions, the state asks the court to affirm the judgments.
Thank you. Mr. Raymond, you have 5 minutes for rebuttal.
I think it's significant that the motive version had to be explained, not suppressed. What happened here was the motive version was suppressed, and that's how it came out at trial. Again, the prosecutor in this case asked Dr. Caruso, "Are you aware that I just received your report and your rough notes over the weekend?" And she also walked through every report that cross-references each other. There's no mention of the May 11, 2009 report. If you didn't know it existed, it didn't exist. And that is significant when that comes out, because it gave the jury, left the jury with the appearance that the report was suppressed. And I think, the jury could presume that, kind of run away with that and make a lot of presumptions that are all negative against Micah Johnson. And I think, the state just mentioned that, the motive was out there. The motive was never out there from when it was given until trial. The motive, the non-psychotic version doesn't emerge until a weekend in the middle of trial. And yes, his attorneys were stuck with their own deficiency at that point. The jury been impaneled, they're halfway through a trial. Their only defense, and they testified to that at post-conviction hearing, was insanity. In that case, and his defense hinged on Dr. Caruso. Dr. Caruso is the only defense witness that can testify to the ultimate issue of insanity. That's it. And this individual once that the non-psychotic narrative emerges and it appears that report was suppressed in conjunction with the academic misdeed, Dr. Caruso doesn't have any credibility with the jury. And again, this is the individual that Micah Johnson's defense hinges on, and he has no credibility anymore. And all this is a result of trial counsel's failure to present his insanity defense. And with that includes turning over reports, reviewing reports. Trial counsel knew this narrative was out there and made no effort in the almost 2 years subsequent to that to ensure that narrative was included in subsequent reports and addressed. Again, Dr. Smith said it's not uncommon for individuals who suffer from mental illness to want to try and provide a rational explanation. There is people do not want to be thought of as crazy, I think was her testimony. And that can be explained. And I think a reasonable juror could accept that explanation, understand why someone would want to provide a rational motive or rational explanation, because they don't want to be perceived as crazy, because there are negative connotations with that in our society. And many individuals that suffer from mental illness recognize that. And I think it's also significant and brought up by the state about him evading the scene. I think Dr. Smith actually provided an interesting explanation of that. The question is not whether or not someone fled a scene, it's why they fled the scene. I think her example was, were they running from the evil spirit or monster, or were they running away because they believed they had done something wrong? Those are two different things. So simply leaving the scene, there can be a non-psychotic explanation for something like that, and there certainly can be a psychotic explanation for that. But I don't think that is dispositive in the jury's consideration of this issue. Again, the deficiency was in the management and presentation of the defense. It is incumbent on Micah Johnson's attorneys to present a defense. It's incumbent on them to turn over evidence to the state. And it's incumbent on them to review these reports. None of this is Micah Johnson's responsibility. Yes, the narrative was out there and it had to be addressed, but addressing it was not Micah Johnson's responsibility. That was his attorneys in conjunction with Dr. Caruso. That wasn't done here. He was deprived of the effective assistance of counsel under Strickland, the Sixth Amendment to the United States Constitution, Article 1, Section 9. Based on this and our brief in the record, we request this matter be remanded for a new trial. Thank you.
Well, thank you both for your arguments today. That concludes the arguments, and that concludes the term for this for November of the Court of Criminal Appeals. Thank you.
Court of Criminal Appeals of Tennessee stands adjourned.